Greetings and welcome to Summary Judgment, Nature, Purpose, and Application from American Jurisprudence. Greetings to you all. Les TV, Oakland Love. Audit them, and yes, please hit the like. Let's get started. And before we do get started, just to remind everyone, this broadcast is strictly for the entertainment educational purposes of this YouTube channel, not to be used, misconstrued, or abused for anything personal, private, legal, lawful, business, tax, or otherwise, so please don't do this at home. That said, let's get started. So we're going over from American Jurisprudence, 2nd edition, Summary Judgment Summary. Summary Judgment Summary. It sounds strange, but it's a summary of the Summary Judgment section, which is what we're looking at, or the summary judgment volume. Let's first go over the scope. This article discusses summary judgment generally, and in particular, the nature and purpose of, the application of, or motion for, opposition to, determination of, and the scope of relief, and the judgment or order granted or entered on summary judgment. So that's a lot of stuff about the nature and purpose, the application, motion, opposition, determination of, scope, relief, judgment, order granted, entered of summary judgment. It also includes illustrative actions, matters, and proceedings in which summary judgment is authorized or available. Illustrative, illustrative. Federal aspects, that'll be the summary judgment proceedings in federal courts are governed by Rule 56 of the Federal Rules of Civil Procedure, which is treated in this article. Excellent. Also discussed in this article is Rule 12 of the Federal Rules of Civil Procedure, which involves motion to dismiss and motions for judgments on the pleadings, as that rule relates to Rule 56. So Rule 56 is the one that's governing the summary judgment proceedings. And treated elsewhere as the appellate review and voluntary dismissals, action as opposed to motion for summary judgment, etc. But we're going to stick with the scope of this article. And here it is, generally, nature and the scope. Summary judgment is a procedural device for prompt and expeditious disposition of a controversy without a trial. The primary purpose of summary judgment procedure is to determine whether there are any triable issues of facts requiring a formal trial on the merits, rather than to decide factual disputes. So what they're saying here is that summary judgment procedures is to determine whether there are any triable issues of facts requiring a formal trial, rather than to decide those actual disputes. So it's whether there are triable issues, rather than to decide on the factual disputes. Summary judgment also promotes a search for undisputed material facts that can be applied in the judicial making process. So if summary judgment also promotes the search for undisputed material facts. Remember, material facts are those related to the central issue that can be applied in the judicial making process. The purpose of summary judgment is to eliminate trial in cases in which it is unnecessary and would only cause delay and expense. Since when was that an issue? The slow gears of justice, and boy, they sure like expense. Summary judgment is also a useful device for unmasking frivolous claims and putting a swift end to meritless litigation, because it allows a court to move beyond the allegations in the pleadings and analyze the evidence to ascertain whether there is a need for trial. The summary judgment procedure prescribed in Federal Rules of Procedure 56 is designed for the prompt disposition of actions in which there is no genuine issue regarding any material facts. This rule contemplates an inquiry in advance of trial as to whether there is a genuine issue, and may be invoked for the purpose of striking sham claims and defenses that obstruct a prompt determination of the truth. A state is subject to summary judgment rules if it has consented to the suit. So that's an interesting footnote there, and that's looks like 9. Boy, those are tiny footnotes. Let's see, these are just citations of cases. All right. As whether states, yeah, that's 72 AmJur states, territories, and dependencies. Let's go over here to the chat and see if there's anything that we need to catch up on. It looks like, seems we're all caught up. Pretty thin notices going out, I noticed on this one. Nevertheless, let's continue. Here's our supplement for section 1 here. Cases. Although courts should be cautious about granting summary judgment in cases where motive, intent, or state of mind are at issue, the salutary purposes of summary judgment, avoiding protracted, expensive, and harassing trials, applies no less to discrimination cases than to other areas of litigation. So discrimination cases can have summary judgment too. The motion for summary judgment is designed to eliminate the delay and expense of litigating an issue where there is no real issue to be tried. Summary judgment is designed to test the sufficiency of the evidence to determine if there is sufficient evidence at issue to justify a trial or formal hearing on the issues raised in the pleadings. Florida Bar versus Green, 2006. A motion for partial summary judgment is not a special remedy or a special application to the court, as it is a special proceeding, but rather is merely one particular tool that may be used to resolve certain issues in the case. Wow. That's Keefe versus State of Department of Motor Vehicles. Wonder where that case went. Which direction on that? Summary judgment is a rule designed to eliminate the necessity of a formal trial, where only questions of law are involved and a fatal weakness in the claim of a party is exposed. That comes from that Rule 56. Here we have Dalton versus Camp, that's North Carolina. The purpose of summary judgments is to eliminate patently unmeritorious claims and untenable defenses. Texas. And we have our references here. And let's see here on the chat where we're at. All right, we're back. And 1 second here. If I'm coming through here, please let me know on the chat because I haven't got any feedback. And I'd like to make sure that we are coming through loud and clear. That being said, let's continue. All right. We're on to section 2 now. As a drastic remedy, the limits on use. And we're still in the general about summary judgment. So these are all general descriptions here. Because the practical result of applying the summary judgment remedy is to deprive the party against whom judgment is granted of a trial in the usual course, the remedy is a drastic one. That should be used with great caution, and only in those cases in which the justice of its application is clear. However, summary judgment rules, construed with the due regard, not only for the rights of the persons asserting the claims and defenses that are adequately based in fact to have those claims and defenses tried to a jury, but also for the rights of persons opposing such claims and defenses to demonstrate in the matter provided by the rule that the claims and defenses have no factual basis. Although summary judgment saves time, effort, and expense by avoiding a full trial under certain circumstances, Those savings may not be gained at the expense of denying a litigant the right of a trial if there is a genuine issue of material fact to be litigated. While a motion for summary judgment is not a trial, if it is granted, the motion is the procedural equivalent of a trial. So great care must be taken to ensure that justice does not result from its employment, in that it does not become a substitute for the open trial method of determining facts. So we want to have an open trial method of determining facts, not using summary judgment as a substitute. Because the summary judgment proceeding is a drastic remedy, strict compliance with the applicable rule is required. And this is so whether or not the opposing affidavits are sufficient. Interesting here, this is so whether or not the opposing affidavits are sufficient. So in summary judgment, you're going to have, as we've noticed in our previous series on affidavits, that you're going to have a battle of affidavits and counter affidavits. And this is saying that because it is a drastic remedy, the summary judgment, strict compliance with applicable rules required. And this is so whether or not the opposing affidavits are sufficient. So the battling affidavits cannot overcome the strict compliance with the rule because of the drastic remedy of summary judgment. And that's footnote 6. Let's see what that's about. And that's Manchester Memorial Hospital versus Whitney in Connecticut, 1969. I wish there's a little bit more on that one. But that's it for this section. That's a supplement too. Interesting. Or no, that wasn't the supplement. Section 1 was a supplement. This was straight. The Section 2 is drastic remedy. All right. Let's get on to Section 3 here, statutory and rule provisions, constitutionality. Statutes and rules for providing for summary judgment under reasonable conditions and procedures have generally held constitutional. For example, statutes or rules authorizing a summary judgment upon the failure of a defendant to file an affidavit of merits and defense have been held valid. That one was 1930, People's Wayne County Bank, wow, versus Wolverine Box Company, 1930. Interesting there. Federal Rule of Civil Procedure 56 provides that a party seeking to recover upon a claim, counterclaim, or cross-claim may, at any time after the expiration of 20 days of the commencement of the action or after service of a motion for summary judgment by the adverse party, move with or without supporting affidavits for a summary judgment in his or her favor upon all or any part of the claim, and that a party against whom a claim, counterclaim, or cross-claim is asserted at any time move with or without supporting affidavits for summary judgment in his or her favor as to all or any part of the claim. A summary judgment procedure practically identical with that prescribed by Federal Rule 56 has been held not to infringe the constitutional right of a party to a trial by jury. Interesting, not jury trial, a trial by jury. The fact that the external circumstances may prevent a defendant from taking the opportunity to defend does not make a summary judgment law unconstitutional as denying due process. Wow. Let's see our footnotes here. Of course, we go to constitutional law, the AmJur as a reference. And we're on Section 4, State and Federal Rules. And let's jump over here to the chat. There we go. We got Diesel for We the People News. However, they've been ignoring affidavits and going strictly by motions in today's court. Yes, but in summary judgment, the affidavits are the only evidence sometimes being presented, and that alone can be the ruling on it. So yeah, motions aren't enough because they could be anything. The affidavit at least has some bite to it. As far as evidentiary bite, I should say. All right, we're on to state and federal rules. In states in which the state rule of civil procedure governing motions for summary judgment is virtually identical to the corresponding federal rule, the state courts will look to federal court interpretations of the federal summary judgment rule as persuasive or highly persuasive. On the other hand, a state court summary judgment order may be modified or vacated following removal of the action to federal court upon a determination that the order does not comport with Federal Rule 56. The rule that summary judgment is not granted if there is genuine issue of fact is a procedural rule, which is not affected in a diversity case by a state statute. Diversity case meaning diversity of jurisdiction. So I guess both in federal and state is what they're referring to here. And we'll see as footnote 4. Boy, those footnotes are hard to read. Okay, as to which laws apply in diversity actions, see federal courts. Okay, so that's what that is. And we have a supplement here with cases. Federal rules of procedure, not rule of Texas rules of procedure, govern propriety of summary judgment in diversity case in federal court. Okay, so the federal rules of civil procedure in most states, it's not any different. Some even have it numbered the same. All right, and we're on to section 5. As distinguished from judgment on the pleadings. And jumping over here to the chat, see what we got going on. Oops, loud and clear, good, excellent. So we can continue. Under the federal rules, both a motion for judgment on the pleadings and a motion for summary judgment are available, but they are subject to different requirements. The main distinguishing feature, at least in certain jurisdictions, is that on a motion for judgment on the pleadings, only the pleadings are considered. But on a motion for summary judgment, certain matters outside the pleadings, especially affidavits, may be presented. Wow, so practice guide. If a court does not have subject matter jurisdiction to hear a case, then it cannot have jurisdiction to decide issues of fact and law to grant a motion for summary judgment, which acts as an adjudication on the merits. In such cases, a motion to dismiss for lack of jurisdiction over subject matter is the proper approach. Wow, that's interesting there, and that's footnote 4. Hertz. Martorano versus Hertz. That's in 1999 in Mississippi. Oh, no, that's a different one. It's 1976 in looks like Pennsylvania. And we have Cook versus Children's Medical Group. And then we have Mississippi in 1999. That's what that is. This professional association. I think that's Pennsylvania. I'm not sure. All right. And that's the end of this section, right? Indeed. All right, that nice little practice note there. So this is basically saying that if there's no subject matter jurisdiction, that the proper action is to dismiss for lack of jurisdiction over subject matter. Instead of a summary judgment. All right, generally. So we're on to the generally. And let's jump over here to the chat. See where we're at here. You have rights. Cops have duties. Greetings. It says here, I wrote an affidavit to change status, which declared pro per attorney. In fact, when I filed my motion of default, they filed it and a couple months later dismissed with summary judgment. Which way was it? See, I got summary judgment on my battery upon a peace officer charged for a lack of probable cause. So, but summary judgment for you or for them? I was a little confused there. Maybe pipe that in the chat so we can have clarity on there. That's interesting though. Well, as you can see, it is a tool for summary judgment for you in your favor. Excellent. Well, there it is. As you see right there, the affidavit is the best, one of the best ways to establish what is the language they use here? This is the key right the key phrase when it comes to summary judgments. See here, it'll be this one up here. Bear with me a second because this is probably important to make sure that we have clear understanding here. Oh gosh. Yeah, it must be on sections 3 then. And we'll get back to it here. But the drastic remedy. Here we go. If the trial, there's a genuine issue of material fact to be litigated. So this is the one here, genuine issue. So a genuine issue of material fact, material relating to the central issue of the action, and facts, not presumptions, to be litigated. So a genuine issue of material fact to be litigated. Okay, material fact to be litigated, then it's not eligible for the procedure of a summary judgment. Okay, clear that one up. Let's get back to where we left off here. All right. And this looks like it right here. On to generally. Let me clear this one off here. You have rights, cops have duties. Says, I asked them to show probable cause within 15 days or default, and they failed to show probable cause. Then weeks to months later, they sent me a paper that the district court dismissed, declared summary. And we spoke about summaries in our episodes on evidence in that series. Declared summary judgment for lack of probable cause, and the paper said I would receive no further documents concerning that case or case number. Wow. Well, salute to you. You have rights, cops have duties. And we can see here, this is where the rubber meets the road, where filing these kind of affidavits and challenging the summary judgment when there is a material issue of facts to be litigated is essential to enforce your fair justice. Section 6, generally. The actions, matters, and proceedings in which summary judgments may be rendered are generally specified or at least governed by the authorizing statutes or rules. Remember, this is proceedings, procedures, and that means this is all referring to that substantive law, those positive laws. Some statutes provide that summary judgments are authorized in proper cases in causes of action arising upon contract, judgment, or statute. The construction of a statute presents a question of law that is appropriate for summary judgment. Wow. While summary judgment procedure was originally designed for actions arising out of contract, it has been expanded by many statutes and rules to embrace all types of claims, including those sounding in tort. However, the issue of fraud is not ordinarily a proper subject for summary judgment because, being a subtle matter, proving the cause of action may require a full explanation of the facts and circumstances of the alleged wrong to permit a determination of whether collectively constitute fraud. So interesting there. In fraud cases, summary judgment is not ordinarily a proper remedy. It's being a subtle matter, and proving the cause of action may require a full explanation of the facts and circumstances of the alleged wrong. Wow. The federal rules provide that a party seeking to recover upon or a party against whom recovery is sought on a claim, counterclaim, cross-claim, or declaratory judgment may move for a summary judgment. So seeking to recover upon may move for a summary judgment, or a party against whom recovery is sought on. Wow. The nature of a controversy may render summary judgment inadvisable. For example, a summary judgment should not be based on an indefinite factual foundation involving a welter of statutory or regulatory provisions the application of which may depend on undeveloped facts. There are three classes of litigation that are not usually suited for summary disposition: negligence actions, cases involving states of mind, such as motive, intent, consciousness, conscience, or subjective feelings and reactions, and equitable actions. Interesting. Wow. That's footnote 12. Let's look at that real quick. Equitable. Section 9. I guess we're getting to that next. However, even in cases involving elusive concepts, such as motive or intent, summary judgment may be appropriate if the non-moving party rests merely upon conclusory allegations, improbable inferences, and unsupported speculation. Wow. Now, that's another reason against just using affidavits in these kinds of cases, it seems, because then writings and motions sometimes are just considered that unsupported speculation and improbable inferences and conclusory allegations. Great language right here. Conclusory allegations, improbable inferences, and unsupported speculation. That's some lawyer language there if I ever heard it. In any case, if it is not perfectly plain that the action is within the scope of a summary judgment statute or rule, a motion for summary judgment is improper and should be denied. If it is not perfectly plain, that means every part of it is plain, that the action is within the scope perfectly. Okay, and we have a supplement here, a case supplement. Oh boy. Whether probable cause to arrest. Here we go. You have rights, cops have duties. This might apply here. Let's see. Whether probable cause to arrest existed in a question that may be resolved as a matter of law on a motion for summary judgment if there is no dispute with regard to the pertinent events and knowledge of the officer. Wow. Whether probable cause to arrest existed is a question that may be resolved as a matter of law on a motion for summary judgment if there is no dispute with regard to pertinent events and knowledge of the officer. So only if there's no dispute. Summary judgment is appropriate procedure for resolving challenge to federal agency's administrative decision when review is based upon administrative record, even though district court does not employ standard of review for such motions set forth in the federal rule. Allegations of spoliation do not give rise to an independent cause of action under Texas law. Accordingly, do not constitute claims to attack by way of a no evidence motion for summary judgment. Allegations of spoliation do not give rise to an independent cause of action. Issues of intent and knowledge are not susceptible of being readily controverted and are generally inappropriate for summary judgment. So issues of intent and knowledge, those are not good ones for summary judgment. Summary judgment should not be granted when issues are inherently for those of jury, as in cases of intent. Okay, so we get that. So certain classes of cases, intent, fraud, detailed knowledge, they're not eligible for summary judgment, it seems. All right, we're on to Section 7. And remember, we need to get to Section 9. I wonder what Section 9 is. Let's do a little spoiler and see what it is here. Here it is, Section 9. No. It is equitable actions and specific performance. Okay, so we'll be getting to that soon. And that was referenced earlier. All right. So now we're getting into actions on contracts. Let's jump over here to the chat real quick. All right. Oh, boy. So we got a lot going on here. Yes, great move. You have rights. Yeah, that'd be nice to see. I know you've been doing. Actually, if you go to his channel, I'll pipe it into the chat in a moment. But or by the end of this thing, I'll break away and get that in there. He has a lot of that onto his channel documented already. Yeah, for all intents and purposes, I should have no further actions against me, but there is a justice of the peace telling the court clerk not to file my paper, but to lodge my writs in my file. Wow. While I was going towards trial on my battery upon a peace officer, they charged they wanted me to take 2 deals. When I denied their deals, they added charges. Woo. Now that my original charge I was arrested for was dismissed, they are holding the stacked charges over my head in the lower court, even as the district attorney failed to show probable cause. So is this a case of lack of subject matter jurisdiction where it should be dismissed, or is it a good case to be dismissed on summary judgment, according to the reading so far? And Diesel for We the People News says, we got to be careful with the word facts. Facts is in the middle between truth and false. It's investigation. Indeed, as we were saying with facts, there's subjective facts, objective facts. If enough people believe, have certain beliefs or subjective truth or subjective truths to them, it becomes an objective fact before the court. So there's a lot of cases where, if that's why you have a jury of 12, if they all believe the same subjective truth, it becomes an objective fact to be ruled upon. And You Have Rights says, as long as the justice court clerk doesn't file my affidavit motion, those writs do not move forward and the case is on limbo. Yeah, they have to file your affidavit. I didn't have to file for summary judgment. I filed the motion to default. Yeah, and the motion to default when they were unable to show probable cause. District court dismissed by way of summary judgment. Oh, interesting. For lack of probable cause. I guess that it would work too. Yeah, and let me see if I could just pipe in You Have Rights, Cops Have Duties channel for you guys to subscribe to and to be able to follow his journey with this, because I know he's got a lot of it documented there. Give me one moment and to pull it up here. One moment here. You Have Rights, Cops Have Duties. Share that and pipe it into the chat here. Here it comes. I'm just going to type in the YouTube channel directly in here. There you go. I mean, pipe it in there. Just you can click on that and subscribe to You Have Rights, Cops Have Duties. That's the one right there. Neighbors help neighbors in a peaceful world, indeed. And I got to say that You Have Rights, Cops Have Duties has come in these live streams before. Matter of fact, I recall one on the adverse possession and brought in some of his own experiences. So salute to you, You Have Rights. You're out there pounding the pavement and showing us what happens when the rubber hits the road and where all this does come into play. So it does validate a lot of the learning we're doing here. And so salute to you. All right, we're on to Section 7, Actions on Contracts. The interpretation of an ambiguous contract is a question of law to be determined by the court and may be decided on summary judgment. In fact, cases involving interpretation of written contracts are particularly appropriate for disposition by summary judgment because interpretation is a legal issue rather than a factual one. Legal and factual. See this distinction? So don't think that legal has to always do with facts. Legal has to do with procedure. For example, because the interpretation and construction of insurance policies is a matter of law, such cases are appropriate for summary judgment. However, in a contract dispute, a motion for summary judgment may be granted only if the agreement's language is unambiguous and conveys a definite meaning. Summary judgment is not appropriate if the agreement is ambiguous, because resolving an ambiguous term in a written contract through extrinsic evidence remains squarely within the province of the trier of fact. Issues of contractual intent are also particularly inappropriate for disposal by summary judgment. Also, a question of whether there has been a repudiation of a contract or whether repudiation was justified is a question of fact that generally cannot be disposed of by summary judgment. Here we go, practice guide. The course of dealings between the parties to a contract. The course of dealings between the parties to a contract for the purposes of interpreting an ambiguous contractual term is ordinarily a question of fact. However, if the evidence on the course of dealing is such that reasonable minds could draw but one conclusion, the question is one of law, and summary judgment may be appropriate. Evidence on the course of dealing. Interesting here, on the course of dealing. Course of dealings. That's a good phrase there to know here, huh? Is such that reasonable minds. What's a reasonable mind? What ordinary people are willing to accept as being ordinary, acceptable, could draw but one conclusion. So this is what reasonable people could only draw one conclusion. Then it's no longer a question of fact. It becomes strictly one of law because the fact is established by the reasonable minds drawing that one conclusion of fact. Radio Shack. Wow, that was 5. Footnote 5. Boy, these footnotes are hard to read. Now, you guys can't read them on the screen, I'm sure. Here it is 5. Summary judgment is not appropriate if the agreement is ambiguous. So someone's writing ambiguous agreements with Radio Shack, huh? Katinsky versus Radio Shack, Division of Tandy Court, 1980. Good old days. All right. Supplement cases. Generally, construction of a written contract is a question of law for the trial court for which summary judgment is particularly appropriate. So, construction of written contract is a question of law for the trial court for which summary judgment is particularly appropriate. All right, now we're on to the good part here. Oh no, we're on section 8 still. Still a good part, negligence actions. Let's pop over here to the chat. Let's see where we're at. Hey, greetings, SG. Said just stop by to hit the like. Thanks. It's past my bedtime. I'll listen to work later on. Love the channel. All right. Well, thank you. Really appreciate you coming by. We'll have it here on the replay. You have right says, I've been in political exile while completing these things through the mail. Also special appearance. I have moved this stuff forward by way of special appearance. Nice. And for those that are wondering about what he means by special appearance, we have a good AmJur episode in the AmJur playlist on appearances. We go into detail about the different distinctions, especially concerning special appearances. You have right says, so my channel doesn't have much of these dealings on because I'm trying to get this stuff done without showing the entire hand. Gotcha. All right, well then appreciate you sharing that with us here because these are practical applications of what we're reading right now. Diesel for Read the People News says, so if we're operating in merchant action of contract will apply, buy tickets and such. Yeah, summary judgment would be typically for the merchant actions. So summary judgments, as we, from the law merchant episodes we just went over, was created by the merchant courts, the special courts. It was a creation of theirs, a summary judgment in these kinds of procedures. All right, I think we're all caught up here with the chat. Oh, one more here. Yeah, you'd think they have to file your writs. There's probably other ways to kind of make sure there's other people ensuring they are, but I digress. Let's get back to the subject matter here that we have before us. And negligence actions. Summary judgment is usually not as feasible in negligence actions as in other kinds of litigation, because issues of negligence, including contributory or comparative negligence, are not ordinarily susceptible of summary adjudication for or against the plaintiff or claimant. However, summary judgment is available in some actions grounded in negligence. For example, if a plaintiff with a claim based on negligence cannot recover as a matter of law, the defendant is entitled to summary judgment. Ooh. Observation. Let's see this. What adds both to the intrinsic procedural difficulty of summary judgment and to some of the confusion in dealing with the device and negligence actions is that, even if there is no dispute about how an accident occurred, the presence or absence of negligence often remains a question of fact, which requires a trial under traditional principles of the law of negligence. Because the reasonableness of a party's action is a question whose resolution requires a determination of the reasonableness of those acts and the conduct of parties under all the facts and circumstances of the case, the issue of negligence must normally be presented to a jury and cannot be disposed of by summary judgment. So, where negligence doesn't seem like it's really works well with summary judgments. While it cannot be said that under no circumstances can the question of gross or wanton negligence be disposed of on summary judgment, most of the cases have resulted in a holding that summary judgment was not proper under the circumstances of the particular case. In some such cases, however, summary judgment has been granted, and that's footnote 8. Let's see where it has been, because it's been Herring versus, Florida 1955. Who knows what that was? That seems like a pretty rare case. That'd be interesting to know what it is, because that would be a summary judgment being granted in a negligence case. That's a summary judgment being granted. Apart from the presence of other issues, if there is a question as to whether the plaintiff has sustained any injuries as a result of the accident, summary judgment is not appropriate. However, summary judgment may be granted on the issue of liability, even if there is a triable issue as to damages. Ooh. Just on the issue of liability, and there's a triable issue as to the amount of damages. Wow, that's slick. That comes in section 66. We could take a peek at that real quick, because we're not going to get to that tonight. Let's take a sneak peek at section 66. All right, where are we at? Section 8. Oh boy, it's way down here. Oh, I think I went too far. Nope, didn't go far enough. $66, it said, right? It's right down at the end here. Wow. All right, almost there. Here we go. 66, judgment on sole issue of liability, assessment of damages. Oh, under Rule 56C and similar state rules. Even if there is a genuine issue as to the amount of damages, a summary judgment may be rendered on the issue of liability alone, even if there is an issue. Thus, a plaintiff or claimant may be granted a summary judgment only to a determination of the amount of damages. Wow. A summary judgment on the sole issue of liability granted is interlocutory in character. So it may be modified or vacated at any time before final judgment, and a summary judgment for plaintiff on the issue of liability may be set aside, and a summary judgment for the defendant granted. Wow. All right, so we really get ahead of ourselves here. Let's get back on the ground here where we were in the easy section here. All right. Thanks for bearing with that digression. Let's get on to, here we have some more cases after the footnotes, huh? Oh no, I shouldn't have done that because we got ahead of ourselves. That was what, footnote 10? The doctrine of assumption of risk cannot be applied in the context of summary judgment because it must be submitted to the trier of fact. Assumption of risk has to go to the trier of fact. It's not going to work in the context of summary judgment. Interesting. All right, so let's look at the supplement here of the cases. Engineering consulting firm for municipality had to explain why its evidence of its lack of awareness of rock at construction site was relevant, and why such evidence negated elements of contractors' claims that relied on the existence of unforeseen rock at construction site in order to obtain summary judgment against contractor in contractor's lawsuit alleging negligence against engineering and consulting firm from municipality that related to termination of construction contract by municipality under North Carolina law. Wow. Wonder where that rock came from. Summary judgment is rarely appropriate in negligent cases because they are particularly fact sensitive and are governed by a standard of the objective, reasonable person, one best applied by a jury after hearing all of the evidence. Wow, okay. All right, now we're getting on to equitable actions and specific performance. This is one where it said before that it wasn't really applicable, so let's see what they have to say on that. But first, let's get to the chat. You have rights, cops have duty. There's coleslaw that says that when you hand over a lawful motion to a clerk, that lawful documents are as good as filed. So later the clerk and the justice of the peace telling her not to file. Well, that'd be like dereliction of duty. Yeah, that gets pretty. I don't want to go down that yet. There's a lot of stuff. My papers will be in trouble for obstruction of justice. Of course, if you have evidence of the delivery with, registered mail signature, I believe when a government office, they've already made an agreement with the post office when they sign receipt of any kind of mailings that are sent through registered mail in the post office that they've accepted service, and that would be evidence that they did receive it. So that would be a due process issue, it seems. Summary judgment is usually granted when there is no probable cause to move forward with a claim. So basically, in summary, they bow out of the claim. Basically, it is not that the claim no longer exists. Right, because it could always come back with evidence later and get a full judgment. Indeed. Right, a summary judgment is not have as much weight as a final judgment. And we did that in the series on judgments, too, on the American Jurisprudence playlist on this channel. You can check that, and exactly what you have rights, cops have duty says is correct. But that there isn't enough proof to move forward in the claim. Right. And it just means that it's still open, that it could be, hopefully, from Escobar. Yeah, exactly. Proof of service by way of registered mail. Yes. So that there is evidence. You have some evidence there. Excellent. All right. So I hope we're all learning here along the way. And again, salute to you have rights, cops have duties for going out there and treading those waters. So we're on to Section 9, equitable actions, specific performance. Although equitable actions are not usually suited for summary dispositions, summary judgment is available in such actions if the general requirements are met. For example, summary judgment for the plaintiff is appropriate in an action for specific performance of a contract if there is no genuine issue of material facts shown, and a plaintiff is entitled to specific performance as a matter of law. Also, the issue of a plaintiff's laches may be determined on a motion for summary judgment. So, lashes is a lapse in time. There is nothing in Federal Rule 56 to support a conclusion that summary judgment is not available in actions that were formerly equitable suits. All right, and that was brief. Takes us right on to the next one. Oh boy, summary judgments involving will, probate, contest, or construction. Section 10. Question of the availability of summary judgment procedure and the propriety of granting summary judgment in will, probate, or contest proceedings has arisen in a number of cases. In some cases, the court, while recognizing that such procedure might be applicable in certain instances, have held that it was not available under the circumstances considered, while in other cases, it has been ruled available and applicable. Wow, so will's estate, so probate. This is going to be complex as it is. So here's some cases, a genuine issue of material fact as to whether testator had lacked testamentary capacity at the time she executed her last known will, precluding summary judgment in action brought by testator's family members to annul the will. A genuine issue of material fact existed as to whether testator executed her last known will under the undue influence of her caregiver, precluding summary judgment in action brought by testator's family members to annul the will. Okay, so those are pretty dark cases to read about. On to affirmative defenses, res judicata. A summary judgment may be properly based upon an affirmative defense, such as a valid release. Whether it is gained by way of defense or asserted by a plaintiff, counterclaimant, or cross-claimant in a judicial proceeding as ground for recovery, the plea of res judicata may be raised by motion for summary judgment under Federal Rule 56 or similar state rules, statutes or rules. Collateral estoppel may also be invoked by a motion for summary judgment. However, a court should not grant summary judgment on res judicata grounds if the scope of the earlier decision is unclear. All right. So maybe based on affirmative defenses, summary judgment. Here's our supplements here. Summary judgment is the appropriate method for resolving a claim of res judicata. All right, let's help everyone out here with res judicata and take a quick jump over here to Black's Law. Because we don't need to be pretentious here. Not everyone knows what res judicata means. And I'm not going to sit here and interpret something when we have the text before us. While this is scanning up here, let me check over here to the chat. This is a scanned edition here. It takes a while to catch up with the cursor. You Have Rights says, I am sitting here wondering why this stuff is easier for me to comprehend and how I'm holding such an understanding as it weighs these principles. It has come by way of natural progression, trial and error. So some say I'm smarter for it, but I just think I am tired. Malicious prosecution will have a guy fighting for his life, seeking friends and information at every turn. Well, it takes struggle to make progress. Lack of probable cause is an affirmative defense, and my default motion was an estoppel. Excellent. Yes, indeed. So let me get over here. By the way, this is a great word. It falls on here. Pecuniary, of course, it means of or relating to money. Great little word. Pecuniary ability to make income from any sources. All right. Res judicata. Let me get this thing moving a little faster here. Oh, Lord. Went too far. All right. It should be getting a little bit more responsive. Here we go. Come on. All right. So we need to get to res judicata. Oof, slow down there. REMIC, the real estate mortgage investment conduit. No definition, just the abbreviation. All right, I digress. Let's get back to res judicata. Lord, a lot of R's, aren't there? Oh, passed it, didn't I? Res. Can look on both sides of here. Yep. Res Q. Would have been nice if they just separated the res with the alphabetically from the rest, but they just stick it in here. So we should be getting there. HI. Gosh. Resin. Oh gosh, a lot of R. Res eyes. Okay, here we should be getting there. Resisting unlawful arrest. The act of opposing a police officer who is making an unlawful arrest. Most jurisdictions have accepted the model penal code position prohibiting the use of force to resist an unlawful arrest when the person arrested knows that a police officer is making the arrest. But some jurisdictions allow an arrestee to use non-deadly force to prevent the arrest. That's interesting. And this is 9th edition. This is pretty current. All right, we're on to res judicata. Judicata or cata. Okay, well, first one's res judicata. Res judicata. Res. Okay, res. That's Latin for you. All right, 17th century. An issue that has been definitively settled by judicial decision. This is like your stare decisis and all that, right? An affirmative defense, also, that's one definition. It's also an affirmative defense, barring the same parties from litigating a second lawsuit on the same claim or any other claim arising from the same transaction or series of transactions, and that could have been, but was not, raised in the first suit. Three essential elements are: 1, an earlier decision on the issue; 2, a final judgment on the merits; and 3, involvement of the same parties or parties in privity with the original parties. Restatement, second of judgments. Oh, okay. Also termed res adjudicata, same one there, claim preclusion, doctrine of res judicata, of collateral estoppel. Res judicata has been used in this section as a general term referring to all of the ways in which one judgment will have a binding effect on another. That usage is, and doubtless will, continue to be common, but it lumps under a single name two quite different effects of judgment. The first is the effect of the foreclosing any litigation of matters that have never been litigated because of the determination that they should have been advanced in an earlier suit. The second is the effect of foreclosing relitigation of matters that have once been litigated and decided. The first of these, preclusion of matters that were never litigated, has undergone the same true res judicata, or the names merger and bar. The second doctrine, preclusion of matters that have once been decided, has usually been called collateral estoppel. Professor Van Vestel has long argued for the use of the names claim preclusion and issue preclusion. Wow, that's nice. That's rather more clear. Claim preclusion and issue preclusion for these two doctrines. And this usage is increasingly employed by the courts, as is by the restatement of second judgments. So, there we go. Deep dive into res judicata. Let's get back to where we were here. Thanks for sticking with me through that, everyone. You have rights, cops have duties says it stops them when you ask them to show probable cause. They cannot find that cause to present in order to move forward with their claim. They have no other choice but to dismiss. Yeah, estoppel by conduct, I think that is. Have to go to the bank, not the most safe thing to do in the foreign country. I'll try to make it back here in 15, 20 minutes. You're still presenting live. I'll be back. All right. As soon as you get into the charges against you situation, it's good to file the affidavit declaring yourself your own attorney and then filing the default motion asking them to show probable cause. Yes, I agree. And excellent. Thank you so much, and salute to you. You have rights, cops have duties. Always a pleasure to have you here on these streams. You bring a wealth of knowledge and actually experience and knowledge, which is the keys to wisdom. So let's continue here. All right. What are we on to here? Generally. In general. Generally. Okay. Section 12, generally. Under both the federal rules and some state statutes and rules, a party may move or apply for a complete or partial summary judgment. Also, a court may allow a partial summary judgment even if the party asks for a complete one, depending upon the circumstances of the particular case. Cases. Here's a supplement. Defendant was not entitled to file summary judgment motion at any time without district court's permission in complex multi-district litigation. Rather, district court had authority to adopt special procedures to manage litigation through, including limiting timing of summary adjudication that might otherwise exist under governing motions for summary judgment. Interesting there. And then it's time to move. Wow. Section 13, time to move. Federal Rule 56 provides that a party seeking to recover upon a claim, counterclaim, or cross-claim may move for summary judgment at any time after the expiration of 20 days from the commencement of the action or after service of a motion for summary judgment by the adverse party, and that a party against whom a claim, counterclaim, or cross-claim is asserted may move for a summary judgment at any time. Some state rules, however, specifically provide that a motion for summary judgment may not be made until issue has been joined. Caution: a pretrial order limitation for filing motions for summary judgment is not a bar to the later filing because Rule 56 expressly authorizes the defending party to move at any time for summary judgment. Filing motions is not a bar to later filing at any time. Oh, interesting. Okay, anytime. It means anytime, even later. A motion for summary judgment is not premature because discovery has not been completed. If a non-movement requires more time for discovery, his or her remedy is to seek a continuance or other order under Rule 56. A motion for summary judgment may be properly considered after a mistrial has been granted and before the case has been reset for a new trial. Ooh, that's interesting there. Wow, that's footnote 6, 1975. Oh, here we go, some more cases. Wow, we got a lot of cases here. District Court did not abuse its discretion in allowing plaintiff to file motion for summary judgment more than 9 months after deadline for filing dispositive motions, even though plaintiff claimed that the motion was late because he finally obtained eyewitness declaration corroborating his allegations, where plaintiff had earlier supplemented opposition to defense motion for summary judgment with declaration. Defendant was not entitled to file summary judgment motion at any time without district court's permission. And this is the one we read before there. Let's see here. Yeah, that's just a reference to it there. Let's see here. Affidavit submitted by corrections officials in inmates section 1983 action alleging violations of his free exercise of rights under First Amendment warranted denial of his summary judgment motion as premature. Officials had not sufficient opportunity for pretrial discovery and as to circumstances surrounding the inmate's request for permission to attend services. Wow. Whether requests were timely and compliant with corrections policies, whether it denied, and so the denial was related to legitimate penological concerns. Penological. All right. A second here. My favorite word today is usurpation. Yeah, there's quite a bit of that going on, isn't there? And you have rights that give them 15 days to a probable cause or default. 15 days is the due process time limit set by law, and I'm sure we'll find that in the federal rules too. Plaintiff's motion for summary judgment was procedurally defective, where a motion was filed after time for serving dispositive motions had passed and plaintiffs failed to submit statement of undisputed facts. All right, now we're getting down to successive motions. Section 14. It has been held that after a motion for summary judgment has been denied, another motion may be filed by the same party provided that the movant submits additional affidavits, depositions, or other forms of evidence or materials that were not before the court on the earlier motion. However, it has also been held that a trial court may reconsider a previously denied motion for summary judgment even in the absence of new evidentiary material. Also, has been held that if a defendant's previous motion for summary judgment had been denied, the trial court is not precluded from granting a summary judgment on the defendant's second motion by treating it as one for reconsideration if there has been a clarification of the law. Wow. If one judge denies a motion for summary judgment, another judge may not reconsider and grant summary judgment on the same issue. Oh, if it's been denied, it doesn't get another judge may not reconsider on the same issue. Wow. A rule that parties defending against claims may move for summary judgment at any time does not limit the number of times a party may move for summary judgment. Wow. No limit at any time. Here are some cases. To the extent the plaintiff's equipment supplier's motion seeking recovery of additional amounts from contractor after plaintiff obtains summary judgment holding contractor liable for majority of amount sought in action seeking reimbursement for liquidated damages paid by supplier to construction project owners with subsequent motion for summary judgment. Such motion was procedurally improper, where supplier raised no new facts or arguments that could not have been raised in a first round of briefing, and other issues remained pending that would require further briefing on trial. Amended motion for summary judgment by plaintiff incorporating supporting papers original motion. Okay, so interesting there. Pleading and practice forms. Wow, we're on to oral motions. It has been held, this is section 15, it has been held that a federal court may grant summary judgment upon a party's motion that is not in written form. However, it has also been held that Rule 56 does not authorize oral motions for summary judgment. No, what state was that then? It's footnote 1, New York, 1967. But 1982 says that you can't have oral motions. And here we are to section 16, notice. Under Federal Rule 56 and similar state rules, a motion for summary judgment must be served at least 10 days before the time fixed for the hearing. Under this and similar state rules, before a summary judgment may be granted, 10 days' notice must be served upon the adverse party, or the judgment will be reversed. The party against whom a summary judgment will be entered must be given adequate advance notice and an opportunity to demonstrate why it should not be entered. The purpose of this requirement is to give the non-moving party a reasonable opportunity to discover and submit opposing material to create a genuine issue of material fact. This is a good one here. 2000. Yeah, so that's a pretty good one there. Let's see here. And as a general rule, if an attempt is made to bring the motion on for hearing in less time, it should be not denied with leave to renew, or set for a new hearing 10 days from the date of the motion. However, a motion for summary judgment will not be denied for this reason if it has been argued on the merits. There is no contention of prejudice, and a complete set of affidavits in objection to the motion has been submitted. Entry of summary judgment by the court, sua sponte, is inappropriate if it takes a party by surprise. However, the harmless error doctrine applies if the trial court fails to give notice and grant summary judgment sua sponte. So sua sponte is just on the court's own decision, on their own spontaneously. And here are some more supplements in the cases. Since it is not obvious to a layman that when his opponent files a motion for summary judgment supported by affidavits, he must file his or her own affidavits contradicting the opponent's if he wants to preserve factual issues for trial, either the district court or the moving parties to supply the pro se litigant with notice of requirements of the summary judgment rule. Ooh, that's another interesting one there too, huh? And we have the plaintiff was not entitled to conduct additional discovery before a court decided summary judgment motion, where he did not depose any witnesses until after discovery cutoff date had passed, and he had been granted one extension, and plaintiff failed to provide affidavits setting forth particular facts expected from additional discovery. And for purposes of summary judgment motion, district court would consider plaintiff's statements of uncontested facts only those facts with specific reference to record, inasmuch as information in question was available to plaintiff. Plaintiff had ample time to conduct discovery, and plaintiff could not excuse his failure to make specific references simply by stating he needed to conduct further discovery. Ooh. So there's some pretty good ones in here too. And these are just those are referenced directly in the supplement there. All right, this takes us on to the next section into burden of proof. And I believe we're going to, let's see, how long we've been on this one here? Quite a while. Yeah, this is a good cutoff point, and we're going to continue on this section for the next part. We're going to do a part 2 with this because we've already just digested a lot, but here's a little teaser for burden of proof. There's no genuine issue. Movement must sustain the burden of proof. Thus, a party moving has a burden. So as we get into this, we're going to get into a lot more detail here also, as you see here, the next following section. Yes, we're going to get into burdens. I think I just lost the stream for a second. That means it's time to cut it. All right, with that said, we're going to be leaving off now. So, summary judgments. Now we've gone over the nature, the purpose, and the application. We're going to dig deep into more details, gone over some interesting cases. We've had the fortunate appearance here of you have rights, cops have duties, to throw in some practical applications too to further accentuate our educational experience here tonight. So I'd like to thank you all for attending. This ended up being a really good stream. I think we all should have obtained a lot of good value from this. And once again, I hope you all will show up for the next one. We'll see you then. Peace out.